Bank Secrecy and Money Laundering, Part 2.
This course explains your basic responsibilities under the Bank Secrecy Act and your obligation to be alert for and report large currency transactions, suspicious activities, and other reportable transactions. We'll also cover customer identification requirements, new account openings, and the importance of a strong Customer Identification Program, CIP.
This is Part 2 of 2. In it, we'll focus on CIP requirements, CTR and SAR identification procedures, and the exemptions, record-keeping, and non-compliance penalties you need to be aware of. Let's begin with a quick recapping of Part 1. You are required to carry out 4 key compliance activities to support anti-money laundering efforts. Report currency transactions, single or a series, totaling more than $10,000 in a single day. Report suspicious activity. Keep records of financial instrument purchases with $3,000 to $10,000 inclusive in currency. Comply with BSA exemptions rules for designating customers. Money launderers and terrorists are familiar with BSA reporting requirements, however, and use all sorts of tactics to get around them. That's why your institution must have customer due diligence and customer identification programs in place to help recognize suspicious transactions and activities. Institutions are also required to file a SAR, a suspicious activity report, with FinCEN whenever you suspect illegal activities that meet specific reporting thresholds, and whenever you detect or sense the red flags of illegal financial behavior. And the 4 most frequently used forms you must use to comply with the BSA are the Currency Transaction Report, Suspicious Activity Report, Currency or Monetary Instrument Report, and the monetary instrument records used by your institution. The Bank Secrecy Act also imposes rules for the collection and verification of identifying information. We turn now to the required identification procedures for customers who open new accounts and the records you must produce and keep. CIP procedures. Who can and cannot be exempt from these rules, and those non-compliance penalties I mentioned.
Institutions required to have an anti-money laundering compliance program are also required to make a Customer Identification Program, CIP, as part of their overall program. Let's start with the procedures required for identifying and verifying the identification of customers who are opening accounts. First of all, there are some pretty specific definitions for who is a customer and for what is an account. A customer is any person that opens a new account, and any individual who opens a new account for a person who lacks legal capacity, such as a minor, or an entity that is not a legal person, like a civic club. A person includes individuals, corporations, partnerships, trusts, estates, joint stock companies, and other entities that may be defined as legal personalities. The definition of customer does not include a federally regulated institution or a state-regulated bank, governmental agencies and instrumentalities, companies that are publicly traded but only for their domestic operations. A person that has an existing account with your institution, provided you have a reasonable belief you know the true identity of the person. An account is a formal banking relationship established to provide or engage in services, dealings, or other financial transactions, including a deposit account, a transaction or asset account, a credit account, or other extension of credit. An account also includes a relationship established to provide a safe deposit box or other safekeeping services, cash management services, custodian services, trust services, prepaid cards. Under the CIP rule, these prepaid cards that provide the ability to reload funds, access to credit, or overdraft features should be treated as accounts because a formal banking relationship equivalent to opening an account is created. An account does not include a product or service for which a formal banking relationship has not been established, like check cashing, wire transfers, or sales of checks and money orders. An account that an institution acquires through an acquisition, merger, purchase of assets, or assumption of liabilities. Or an account opened for the purpose of participating in an employee benefit plan established under the Employee Retirement Income Security Act of 1974. Now then, some customers aren't actual people. They're what's called a legal entity. Corporations, partnerships, limited liability corporations or partnerships, trusts, and other organizations. You may need to determine the beneficial ownership of a legal entity, in addition to confirming the identity of the organization itself. Of course, before you can determine who the beneficial owners of a legal entity are, you must understand the two concepts. First, what constitutes a legal entity that can be owned? Well, a legal entity is created by the filing of a public document with a Secretary of State or similar office, or formed under the laws of a foreign jurisdiction that opens an account. Some entities, of course, are exempt from this definition, including state, federal, or local government-regulated institutions, publicly held corporations, SEC-registered investment companies, public accounting firms registered under Section 102 of the Sarbanes-Oxley Act, bank holding or savings and loan holding companies, state-regulated insurance companies, any legal entity that opens a private banking account that is subject to FinCEN's private banking account rules. So, what is a beneficial owner? To answer, there are two prongs, as FinCEN calls them, both of which must be determined for most legal entities. Ownership. Owners are those persons, if any, who in any way own 25% or more of the equity in a legal entity. Up to 4 individuals can satisfy this ownership definition, depending on how many of them own 25% or more of the entity. Control. A controller is an individual with significant authority to run the entity, such as a chief executive officer, chief financial officer, chief operating officer, managing member, general partner, president, vice president, treasurer, or any other individual who regularly performs similar functions. only one individual is to be listed as a controller. If the legal entity is a nonprofit that has duly filed its organizational documents with the appropriate authority, or a pooled investment vehicle operated or advised by a financial institution, then only an individual who controls the entity must be identified. The identification and verification of the entity's ownership is not required. If a trust owns 25% or more of the equity in a legal entity, then beneficial owner means the trustee. If an exempt entity owns 25% or more of the entity's equity, no individual needs to be identified as an owner. As a covered institution, you're allowed to rely on the efforts and findings of another institution to establish and verify the beneficial ownership of a legal entity customer, provided that that reliance is reasonable under the circumstances. The other institution is subject to FinCEN's anti-money laundering program requirements, and the other institution is contractually required to certify that it has implemented its anti-money laundering program, and that it or its agent will perform the specified requirements of your covered institution's procedures to comply with the beneficial ownership rules. All the information you gather about a legal entity, its ownership, and/or control may be documented using the FinCEN form entitled Certification Regarding Beneficial Owners of Legal Entity Customers, or a similar form that gathers all of the same details. When confirming the identity of a customer under your CIP procedures, you should receive proper identification before you open an account. Proper identification is that which verifies the identity of the customer, is the most difficult to obtain illicitly, is the most difficult to counterfeit. But no single form of identification can be guaranteed to be genuine. That's why the identification process should be cumulative and obtain enough information and documentation to ensure that, under the circumstances, you have properly identified a prospective customer. Identification documents for individuals should include a photograph and description of the individual, along with his or her signature. Your institution determines what form of ID you can accept as proper and satisfactory, based on its analysis of the risk associated with various types of accounts and customers, and the various methods of opening accounts. Procedures for verifying ID information, which we'll be talking about a little later, are also based on risk analysis. Examples of acceptable forms of identification for an individual opening a new personal account include a valid driver's license with a photograph, a U.S. passport, a foreign passport along with a U.S. visa or an alien registration card. Some institutions also consider acceptable certain ID cards issued by Latin American countries known as cédula cards. Some Mexican nationals carry a card known as a matricula consular, issued by the Mexican government through its consulates. FinCEN recognizes the Latin American
cédula cards
as valid, but the FBI and Department of Justice have raised issues regarding the reliability of
matricula consular cards
for identification purposes. Because of this, under a risk-based CIP, banks choosing to accept them may want to consider additional forms of identification verification. Be sure you know your bank's policy on this issue. Some secondary forms of identification require supporting documentation. These include a student ID card with a photograph, a major credit card with the account status verified, an employer ID card, an out-of-state driver's license, if not accepted by itself, or a current utility bill from the customer's place of residence. Make sure you know the forms of identification required by your institution's CIP procedures. And by the way, your institution is required to give customers adequate notification that it will be requesting information to verify their identities. This notice generally describes the identification requirements of the CIP rule. The rule includes model language that can be used for this notice. An adequate notice is provided in a manner reasonably designed to ensure a customer is able to view it or is otherwise given notice before opening an account. For example, depending on how an account is opened, an institution may post a notice in the lobby or on its website, include the notice in its account applications, or use any other form of written or oral notice. Another key CIP rule applies to the way in which you verify the identity of persons opening accounts. Basically, the rule describes a documentary and a non-documentary approach for both individuals and businesses. Documentary verification includes items such as driver's licenses for individuals or registered articles of incorporation for businesses. Non-documentary verification includes contacting a customer after an account is opened or obtaining a financial statement. We'll look first at the requirements for verifying individuals. The minimum information you must record about an individual before opening an account is name, date of birth, and residential or business street address. If the individual has no residential or business street address, you must obtain either an Army Post Office, APO, box number, a Fleet Post Office, FPO, box number, or the residential or business street address of next of kin or another contact individual. In addition to name, DOB, and address, for a U.S. citizen, you must also record a Social Security number or evidence that the individual has applied for one. If the individual opening an account is doing so as a sole proprietor, an Employer Identification Number, EIN, or evidence of an application for one can take the place of a Social Security number. Your institution may allow accounts to be opened for an individual who has applied for but has yet to receive a Social Security number. If so, your CIP must include procedures to confirm that the application is filed before the individual opens the account and to obtain the Social Security number within a reasonable period of time after the account is opened. If the customer is a non-U.S. citizen, in addition to name, DOB, and address, you must also record one or more of the following: a U.S. taxpayer ID number, a passport number and country of issuance, an alien ID card number, the number and country of issuance of any other unexpired government-issued document with a photo or similar safeguard that gives evidence of nationality or residence. When it comes to opening a credit card account, if permitted by your CIP, you can rely on the minimum required identifying information from a third-party source, a credit bureau, for example, before extending credit to the customer. There are several acceptable methods for verifying the information you record about individuals. If the customer is present when the account is opened, it's often enough just to carefully examine the documents presented and to keep records of them, as required by the CIP rule. More on this later. The procedure you'll follow will depend on your institution's risk analysis and on whether or not you're familiar with the types of documents provided. If you are not familiar with the documents, like a foreign passport you've never seen before, your CIP should require additional steps, asking for additional ID, for example. If the customer is not present, internet banking, banking by phone, that sort of thing, you have to use other methods. Different institutions do different things. That could include one or more of the following: asking the customer to fax or mail a copy of identifying documents, calling the customer to confirm the account opening, confirming address and phone number using a reverse telephone directory, independent verification through a credit bureau, public database, or similar source, checking references with other financial institutions, obtaining a financial statement from the customer. Are you familiar with your own institution's procedures for this situation? Make sure you are. The rules for recording and verifying the identity of a business are slightly different from those for individuals. At a minimum, you must record name, address of principal place of business, local office or other physical location, and the employer identification number. As with the individual, your CIP is allowed to include procedures for opening an account for an entity that has applied for but has yet to receive an employer identification number. In this case, your CIP must include procedures to confirm that the application is filed before the entity opens the account, and to obtain the employer identification number within a reasonable period of time after the account is opened. If a non-U.S. entity does not have an employer identification number, you must request alternative government-issued documentation certifying the existence of the entity. Again, when it comes to opening a credit card account, if your CIP permits, you can rely on the minimum required identifying information from a third-party source, a credit bureau, for example, before extending credit to the business. As with the individual, your risk-based analysis may lead you to use either or both documentary and non-documentary verification. Documents you might require for this include articles of incorporation, a government-issued business license, a partnership agreement, or a trust instrument. Non-documentary verification methods are much the same as they are for the individual, and can include such procedures as independently verifying information through credit bureaus or public databases, checking references with other financial institutions, or obtaining a financial statement from the business customer. If these verification methods are insufficient to verify the business customer's true identity, the CIP may require you to obtain information about individuals with authority or control over the account, including signatories. What if you can't form a reasonable belief that you know the true identity of a business customer? Your CIP should describe when an account should not be opened, you should close an account, after attempts to verify a customer's identity have failed, a suspicious activity report should be filed, and the terms under which a customer may use an account while you attempt to verify his, her, or its identity. At a minimum, the records concerning a customer must include all identifying information obtained about the customer, a description of any document relied upon for verification, noting the type and any identification number it contains, the place of issuance and, if any, the date of issuance and expiration date, a description of any non-documentary methods used and the results of these methods. For a customer who is not an individual, a description of the methods used and the results of any measures undertaken to verify identity by obtaining information about individuals with control or authority over the account, and a description of the resolution of any substantive discrepancy discovered when verifying the identifying information obtained. These records must be retained and maintained according to the CIP rule to prove you fulfilled all identification and verification requirements. Let's delve deeper now into the requirements and procedures surrounding customers involved in reportable currency transactions and suspicious activity reports, CTRs and SARs. Complete and accurate information is tantamount to a successful criminal investigation. If done properly, that's exactly what the filing of CTRs and SARs provide. Although the purpose of both forms is to report individuals and entities involved in a reportable transaction, their rules are separate from the CIP requirements we just discussed. Having said that, the following identifying information is what's needed when filling out a CTR or SAR. Name, address, Social Security or other identifying number, date of birth, proper form of ID. The SAR also requires the customer's occupation and home and work phone numbers. The CTR asks for complete identification of the occupation, profession, or business of the person on whose behalf the transaction is conducted. This applies to a person who conducts a transaction on his own behalf. If a transaction requiring a CTR is being conducted on another person's behalf, identifying information must be recorded about that person too. For the CTR, you must verify identity using normal check cashing procedures for unestablished customers, driver's license or other acceptable form of ID, including military and military-dependent identification cards, state-issued identification cards, passports, non-resident alien identification cards, and any other identification document or documents that contain name and preferably address and a photo. Also for a CTR, you will be required to describe how you identified the person or persons involved in the transaction. In certain circumstances, you can use information previously recorded on a signature card. Your institution might also have special policies and procedures for verifying the identities of elderly or disabled customers who don't have normally acceptable identification. Back now to the records required for monetary instrument purchases involving $3,000 to $10,000 in currency. Bear in mind that the record-keeping rules apply even if the customer first deposits currency, then accesses those same funds to purchase monetary instruments. The Bank Secrecy Act separately specifies the information you need to gather for deposit account holders and non-deposit account holders. If the purchaser has a deposit account with your institution, you must obtain the purchaser's name, date of purchase, type or types of instrument or instruments purchased, serial number of each instrument, and the dollar amount of each instrument. You also must verify that the individual is a deposit account holder or verify the individual's identity using normally accepted identification procedures. The method of verification must also be noted. If the purchaser does not have a deposit account with you, you must obtain the purchaser's name and address, purchaser's Social Security number or alien identification number, purchaser's date of birth, date of purchase, types of instruments purchased, serial number of each instrument purchased, and the dollar amount of each instrument purchased. You must verify the purchaser's name and address by normally accepted identification procedures. You also must record the specific identifying information you use, for example, the state of issuance and number of a driver's license. If a monetary instrument purchaser cannot or will not supply the necessary information for your records, the Bank Secrecy Act requires that you refuse to complete the transaction. Most people, however, will be cooperative. That's because most of the time you'll be dealing with law-abiding citizens who have legitimate reasons to make large currency transactions. Marlene Vondercheck wants to make a large currency withdrawal. She's moving to another state and wants to avoid potential funds availability problems by having currency to deposit at her new bank.
Mrs. Vondercheck, $12,000 is a lot of cash to be carrying around with you. Couldn't we wire the money to your account once it's opened?
No, I've made up my mind. I want cash. There are a lot of unexpected expenses during a move, and I want to make sure I have enough money.
Okay, just please be careful.
Oh, I will.
Now, since this is such a large currency transaction, I'm required to get some more information. Could we start with your driver's license or some other form of identification?
Sure. Here you go.
Most legitimate customers will be just as forthcoming as Mrs. Vondercheck. They don't mind sharing information with you because they don't have anything to hide. If a customer does complain, you generally can smooth things over. So let's see how you do with someone who's not quite so cooperative. For her college graduation, Mary Molina received cash gifts from various wealthy relatives, totaling $4,500 in currency. She tells you she wants to buy a money order to pay for a laptop for school. She does not have a deposit account. If Ms. Molina refused to provide all the information you needed, you would have no choice but to say, "I'm sorry, but I need this information to complete this transaction. I can't complete the transaction if I don't have it." While it may be difficult to say no sometimes, according to the Bank Secrecy Act, that's exactly what you must do in that situation. In this lesson, we'll be covering who may and may not be exempted from reporting requirements, the record retention requirements imposed by the Bank Secrecy Act, and the penalties for violating the law. So, who can be exempted? You are not required to file a CTR when the transaction is being conducted by an exempt person. We're still using the CIP's definition of person, but individuals cannot be exempted unless they're exempt as a sole proprietor, which I'll get to in just a few. Otherwise, the following entities are automatically designated as exempted persons. Banks, for transactions done within the United States. In other words, currency transfers to banks outside the U.S. would not be exempt. And government departments and agencies, and other entities that exercise governmental authority. Additionally, your institution can designate entities listed on certain national stock exchanges, listed entities, and certain subsidiaries of those listed entities as exempt persons automatically, simply by filing the correct form. Other businesses, including sole proprietorships, can be exempted if they meet the criteria for a non-listed business. Non-listed businesses include various commercial businesses and payroll customers. Insofar as its domestic operations are concerned, and only with respect to transactions made through its exemptable accounts, which I'll define in a moment, a commercial business that is a non-listed business, not a listed entity, may be designated as an exempt person if it meets the following requirements. It has maintained a transaction account with your institution for at least 2 months, or after your institution has conducted a risk-based analysis of the legitimacy of the account holder's transactions. It's frequently involved in currency transactions with your institution in excess of $10,000. FinCEN says frequently means 5 or more transactions over the course of 1 year. And it's incorporated in or conducts business within the United States. Payroll customer, including sole proprietors. Withdrawals for the purpose of payroll can also be exempted under these criteria. To determine whether a non-listed business may be an exempt person, only its eligible exemptable accounts are to be considered, which include transaction accounts. Further, your determination may treat all of the customer's exemptable accounts as a single account. If you do, you must continue to treat those accounts consistently as a single account for purposes of determining exempt person status. The flip side of exemption is who can't be exempt. Businesses engaged primarily in certain types of activities are ineligible for treatment as non-listed businesses. Examples of these activities include the purchase or sale to customers of motor vehicles, vessels, aircraft, farm equipment, or mobile homes. The practice of law, accountancy, or medicine. Real estate brokerage, or the auctioning of goods. Serving as financial institutions or agents of financial institutions of any type. This is a broad definition. It includes some check cashing services and even some retailers, such as grocery stores, that rely heavily on check cashing for revenue. However, some institutions may be exempted if they qualify for the automatic exemption as a bank. Chartering or operation of ships, buses, or aircraft. Gaming of any kind, other than licensed pari-mutuel betting at racetracks. Investment advisory services or investment banking services. Pawn brokerage. title insurance and real estate closing. Trade union activities. Any other activities that may be designated by FinCEN.